Hello, those of you who just joined us, welcome. As ever, we'll be starting in a few minutes. Give everyone a chance to join us. Welcome, everyone. I am alive. If you think I'm quiet and still, don't worry. I'm just having a look, seeing how many people have joined us. We will be going in a couple of minutes. Welcome, everyone. Numbers are creeping up. Well, actually, they're flying up, so this is good. We will start in a couple of minutes.
Still popping through.
Right, I think we will start there. Welcome to everybody. Thank you for joining this Roythornes seminar. Really grateful for you, especially on a Monday morning, coming along and joining us. Nice to see a few old faces, although sadly I can't actually see anybody the way we're running the Zoom, apart from my esteemed colleague Bukola, who's going to be doing some of the talking with me. But welcome, lovely to see some old faces. Delighted to see some of my old drinking partners in the crowd. I'm pleased that you've come along for seminar when I'm talking and not buying you drinks afterwards. So that is nice. Because it's online, there's very little housekeeping to do. I mean, there's quite a bit of dusting behind me that needs doing. If you hear a fire alarm going off, trust me, it's not here. So you might want to have a look at anything at your end that you've left under the grill. We will be off. The subject today is Building Safety Act. We're doing it in two parts because it's quite a long session and a couple of hours is a long time to go through. You're all muted, but we would love your feedback. There's the opportunity to put in questions and answers. That's available to everybody except you, Jan, because amongst the audience, we have my dear friend, Jan Tranzek, who knows more about this subject than I do. So please don't ask any difficult questions, Jan. But I'm really pleased you're here. Many of you will know that Jan and I have talked about safety for many years together. So I'm going to start off. We've got a wide mix of people here. We've got lawyers, we've got housing management, we've got universities, we've got developers, we've got contractors. So hopefully there's a little bit of something in there for everybody. For those of you who aren't lawyers, a little bit about how we pass laws in this country. Usually starts off with a green paper. Then we get a white paper, which is the next stage where we've got a little bit more detail coming in. And then somebody drafts the bill. which is the stage before we go for an act. It goes off to the House of Commons. They will have usually 3 readings. It'll go off to a committee. The committee will produce a report. And in amongst that, it goes off to the House of Lords, who do the same thing, sometimes 3 readings, committees, reports. And occasionally you get what they call ping pong, where the House of Lords makes changes and it goes back to the Commons and the Commons don't like it. All of this takes quite a long time. And then you get what's called royal assent, where now it is the king will be doing it, will pass assent, and it becomes an act of parliament. So you think, great, that's where we are. Everybody knows what stage you're at. It's in force. Well, is it in force? It doesn't automatically come into force. In fact, in this act, some of it's in force and some of it's not. And then we have things called statutory regulations, statutory instruments which pass regulations. So in this act, we've got some bits that are in, some bits that aren't yet in, and some bits that are in that but will be subject to regulations that are being passed in the future. So it's all a little bit of a mess, I'm afraid. So what we will try and do is guide you through where we are and which bits are in force and which bits aren't. I've tried to color code it. So if you see green at the top of the screen, that bit should be in force. If you see white at the top of the screen, it's not yet. If you see orange, it's definitely coming in. But they do like to bring in regulations. The last time I did this, they brought in some regulations about 24 hours before I gave the seminar. Thank you very much, government. But that's why it's all a bit of a mess. The Act is long. It comes in 6 parts, 171 sections and 11 schedules. So there's an awful lot that's around and in existence for us to trawl through. 6 parts are introduction, the Building Safety Regulator, the Building Act 1984 and some changes to that, which includes things like building control authorities. Then they'll talk about higher risk buildings. And in that we'll have important things like accountable person, principal accountable person, and who's going to be in the frame. And part 5, where they've thrown in an awful lot of other bits. And then part 6 at the end is just a general sort of mop up, including the commencement regulations as to which bit is in force. Good thing about part 1 is you really don't need to worry about it. Quite why they've got it in there, I don't know. So let's go straight on to part 2. Which deals with the Building Safety Regulator. The quotes up there are the flannel. This is what they want. So they want them to oversee safety and performance of all buildings and making the sector safer. So promoting the competence and organizational capability of professionals, tradespeople and building control professionals working on all buildings. That's the plan. That's what the regulator is supposed to be doing. It follows on from Dame Judith Hackett's review, which hopefully many of you will have read or have read a summary of, as to how she thought buildings should be made safer. The Building Safety Regulator is going to be part of the Health and Safety Executive. If you haven't done so yet, Google the Building Safety Regulator. You'll go straight through to their landing page, and there's an opportunity to sign up to their newsletter. It's not overly active yet because it's still a fairly new organization, but they do send out some fairly useful stuff every so often. A guy called Peter Baker's in charge. He's setting it up. He's been recruiting people. They're still trying to recruit some more people. Initially, the taxpayers funding it. Thereafter, the plan is that the sector is likely to fund it, and they have the opportunity to recover fees from parties, people that, or organizations that they regulate. We don't yet know how much that's going to cost everybody. At the moment, it is being funded centrally. They've been told they've got to set up 3 committees: the Residents Committee, an Industry Competence Committee, and a Building Advisory Committee. They're looking for people for the Residents Committee. There's still an opportunity to get your residents involved. There is an interim committee that has been set up with 15 people on it. I suspect that all of those 15 will end up on the final committee. But those are the things that the regulators got to look at. In particular, the regulator is going to regulate high-rise buildings, and we'll look at the definition of that later. That will be new high-rise buildings and existing high-rise buildings. So there's going to be quite a lot for the regulator to look at. 7 stories or more, 18 meters or more. Now, how do we measure 18 meters? You might think, well, that's fairly easy. It's just top to bottom, isn't it? Well, not necessarily. And unfortunately, we haven't yet been told definitely how we're going to measure that. We think we're pretty damn certain, because the consultation that went out and finished in July uses the same definition that they use in the building regs 2010. So it's from the lower level at ground. And you might think, well, surely the ground's flat. Of course not. Sometimes you might build a block of flats starting on a slope. So you've got a lower end and a higher end. It's the lower surface that matters. In practice, what you're looking at is where are they going to get their ladders from? If they've got to put the ladders from the lower level, then we'll start counting the distance and the stories from there. And then it's going to go up to the upper floor surface of the top story. So not right to the roof of the upper story, to the upper floor surface, the carpet in practice of the upper story. You ignore a roof space if it is just full of plant, machinery, etc., or any plants and machinery that's on top of the roof. So that's how you're going to measure your 7 stories or more. I can't see that changing. I think that's almost certainly going to come in as the actual definition of what is a high-rise building. Has to be at least 2 residential units in there. That does include, because I know we've got university here, that does include halls of residence. They've not been exempted from that. They still count as residential units. It will also include an obligation to look after hospitals and care homes that are built from now on. So not existing hospitals and care homes, but those that are being built from now on, or where there are substantial changes being made to them. So the regulator is going to have to deal with those as well. What are they going to have to do, the regulator? Well, it's going to become a statutory consultee for planning applications. That's a bit poncy legal phrase. So if a planning application is put in for one of these high-risk, high-rise buildings, then the regulator will have to be consulted. So when the local authority, the council, makes the decision, before they make that decision, the building regulator is going to have to be consulted about what they think. They will also be the building control authority for higher rise buildings. So at the moment, your local authority generally is your building control authority. And of course, they delegated their powers to building control inspectors, many of whom decided to go out of business because of the risks involved. But for these high-rise buildings, the regulator is going to be the building control authority. So they will have to do all those sort of checks. They have been told they've got to give clear accountability to duty holders as to how buildings are designed, built, refurbished, and occupied. And then, of course, I'm sure you've all heard this phrase, the golden thread. The regulator is going to have to make sure there is this golden thread kept for building. So it's got to be there. We've got to know where it is. It's got to be kept safely, and it's got to be kept up to date. So when there's changes in the building, work's done, refurbishment, etc., that golden thread's going to have to be there. And that's down to the regulator to make sure that we're all doing that. When there are certain occurrences happening, so fires going out or prescribed information that is laid down by the government, you're going to have to report that to the BSR, to the regulator there. That's going to be mandatory. And they're going to have to keep a list of all of these buildings, and they're going to have to keep a list of all of the people who have been approved by them to inspect buildings. So that's their job. They will have to do that. Are they going to find this easy? Well, the Act specifically says that local authorities and fire authorities must cooperate with them. You would hope that they would have done anyway, but they've expressly been told that they're going to have to. Their officers can go in and look and see what's there and thereabouts and see if people are doing the right things. For non-residential properties, they can go in without needing a court warrant. For residential properties, they're going to have to get a warrant from the court, but they can go charging in, so to speak, to see what's happening. In case you were minded to do so, you're not allowed to pretend you're an officer of the building safety regulator. Quite how many people wanted to do that at their fancy dress parties, I'm not sure, but it is an offence to impersonate or also, perhaps more importantly, to obstruct an officer of the building safety regulator. They're not almighty. There is the ability to review and challenge potentially their decisions. That will be dealt with and set out in there. So that's part 2, the building safety regulator. Very important. As I say, I suggest you sign up to their newsletter. As I've just done that, I'm going to see if there's any questions in yet. Oh, this is good. Either I've been incredibly clear or you're all fast asleep. But yeah, do put questions in the Q&A or the chat. We will try and monitor them every so often. So moving on to part 3 of the Act, which amends the old and still in place Building Act 1984. So as I said, we've got the regulator, the Building Control Authority for higher risk buildings. And the Act's going to create appointed people who are able to do work on these buildings, and it's going to set out the duties that they have. The regulator is going to have control of the building control profession. As I say, the insurance risks for so many of these building control inspectors became prohibitive. So quite a few of them are no longer in the business, or there's been mergers and that sort of thing. Schedule 4 of the Act transfers the role of what was called approved inspectors previously to registered building control approvers. So that's the register. That's going to be the list of people who can do that. It creates restricted activities, so you won't just be able to dabble in the future with these sort of buildings. And if you're going to, where these activities are prescribed and set out, then only registered building inspectors will be able to deal with those. Okay, part 4 of the Act, higher risk buildings. Very clear and helpful summary. This contains provisions about the management of buildings safety risk as regards occupied higher risk buildings. So we have an awful lot of new definitions, duties coming in, and there's a lot of changes coming into leases. Now, Bukola is going to talk quite a bit about some of the leases and service charge provisions later. We have some new phrases. We have duty holders, and we have a new phrase title, accountable persons. This is where you will desperately think, oh God, I'm not going to be an accountable person, am I? We'll look at those and see who they are in a second. Building safety risk is defined on section 62. So it's a risk to the safety of people in or about a building. So it doesn't just apply to people who are going to be in the building. It could be in communal areas outside. Of course, we've got risks of cladding falling off, that sort of stuff. So it's a risk to the safety of people in or about a building. And they give some specific examples, which of course is the spread of fire, a structural failure, where some or the whole thing may collapse, or some other prescribed matters. They haven't yet prescribed what those other ones are, but let's be honest, those are the 2 main ones we're looking about when we're talking about building safety: fire, the spread of fire, and structural failures. The regulator is going to be allowed to make recommendations. They haven't yet come out those. For higher risk buildings only, it's their remit. They're not supposed to be dealing with all buildings, unless there is a risk of a major incident. So it will be interesting to see what the building safety regulator does and how far he extends his remit. Will he start looking at shopping centres, car parks, public transport, that sort of stuff? We shall see. And the major incidents defined as death or serious injury in significant numbers. So we will see. I suspect at the moment they're going to stick to the tower blocks, and they may then extend that in the future. So that's the definition. 18 meters, high-risk building is at least 18 meters or has at least 7 stories. So either of those could apply. So you could have 5 stories, but if you're over 18 meters, then you're a high-risk building, or you could have only 14 meters, but because you've got 7 stories, and they'd be quite low at that size, but for short people perhaps. But yeah, so for either of those definitions apply, then it is a higher risk building. In there must be at least 2 residential units. So a purely commercial office at the moment where there's nobody living is not defined as a higher risk building under this act. It'd be interesting to see if they change that, because of course office blocks do contain lots of people and still do catch fire. So further regulations can be made, and we shall see if they do bring those in. Definition of occupied, really not very helpful. Section 71, occupied means there are residents of more than one residential unit. I'm not quite sure why they needed specifically to define that and use the words residents in residential units, but there we go. It's there. So any questions coming in so far? No, good. Okay, I'll say good. That's not necessarily good. Please do ask questions if you want to. So accountable person. This is where you need to start concentrating, because you or your organization could be the accountable person. If you are the accountable person, they're going to come after you if it all goes wrong and you're not doing your jobs. Accountable person is a person who holds a legal estate and is in possession of common parts. So legal phrases there. I do apologize. It's not me that drafts these things. So a person who holds a legal estate, they own it. So they could either own the freehold of the building or they could own a lease. And that, of course, could be, excuse me, often a structure of leases. You've got a head freeholder, then you've got a head leaseholder and a sub-leaseholder. If you hold any of those legal titles and you're in possession of the common parts, what does that mean, Daniel? You're going, well, if you can walk in through the front door into the communal stairwell or whatever, because you own the building or you have a leasehold title to the building, then you're in possession of the common parts. If you've granted a lease of a flat, somebody can shut their front door to you and go, stay out. You're not in possession of that, even though you might have a legal title to it. So the accountable person is somebody who owns an interest in the land, the building, and is in possession of common parts. Or the other way you can be an accountable person is if you've got to do some repairs. So you think, well, that says no legal estate. Why would I agree to do repairs if I don't own a legal estate? That, of course, could be the management company who has been set up or appointed. They may not have a legal interest in the land, but they could have contractual repairing obligations. So either of those people can be an accountable person. Just because you own it doesn't necessarily mean that you're going to be an accountable person. You're not an accountable person if every single lease in the block has made someone else responsible for carrying out the repairs. Now, that's likely to be a new development where set up on the scheme is the freeholder and a management company. And then you have the leaseholders, who will have to pay the service charges to the management company, who are responsible for cleaning the windows, looking after the roof, etc. Okay, so that means if all of those leases make that management company responsible for the repairing obligations, then the freeholder can be exempt and say, nothing to do with me anymore. Everybody has understood, everybody has signed up, everybody has agreed to the fact that that separate company from me is responsible for carrying out all of the repairing obligations. But that only works if all of the leases do that. So that gets them off, okay? Similarly, if there is a right to manage company who are responsible for the repairs, then the owner is no longer an accountable person, which is interesting because there was a sort of a quite a few right to manage companies set up a few years ago. In fact, there were some solicitors who got involved and helped people set up these right to manage companies where you got together enough of the leaseholders and they voted in favor. Bukola's an expert on sort of right to manage companies. And if you set up all of those, got all of those votes in and you set up a right to management company, you took away the landlord's responsibility. If that's the case, then again, the landlord freeholder is not an accountable person. The right to manage company is. Whether they're now regretting taking on the management, I don't know, but that's going to be their situation. What about the situation where you've got a freeholder, a head leaseholder who's then granted a full sublease down to someone else? I think the Act is terribly badly drafted. I've had a look at this. I've discussed it with some other lawyers. I think that if you have agreed under your lease and you're a head leaseholder to take on repairing obligations, then I think you are still an accountable person. But I've discussed this with greater legal brains than mine, including various barristers and other well-known legal commentators, and we're not entirely sure. But I think if you've taken on a lease with repairing obligations, even if you're not in possession of the common parts because you've passed that on, then I think you are still responsible. So have a look, get us to look at your head leases if you want, and we will check that. So there's a question about the Defective Premises Act coming. Thank you, Igazi. We will look at that later, but yes, that's great. We'll look at that question later. Please keep the questions coming in. So principal accountable person, so accountable person, those are all the people who are going to be there. You want to try and not be the accountable person if you can, but there's only certain ways you can get out of it. If you've agreed to repair things, then you're going to have to be an accountable person. An accountable person is automatically the common hold association. Common hold is another way of owning blocks of flats. It was set up, it's quite a good idea, but it never really took off. I'm not sure how many common hold associations there are. I think it's still in dozens around the country. But if you're a common hold association, you are automatically going to be an accountable person under the Act. So because we've got different levels and different responsibilities, we might have more than one accountable person for a building. And of course, where you have that situation, the chances are that they're going to go, well, yeah, I might be an accountable person, but he's also an accountable person. So go and have a talk to him. He can do all that. He can carry out his responsibilities. So we will then have this thing called the principal accountable person, on whom the real duties will fall. So the principal accountable person is, and the Act tells us this really helpfully, the only accountable person if there is just one. I would have thought that was bloody obvious, but anyway, that's the initial way you can be in a principal accountable person. But if there's more than one accountable person because there are different responsibilities, or you could say, for example, have a block that's got responsibilities for the outside areas and responsibility for the inside areas. If there's more than one accountable person, it's the person who holds an estate in the structure and exterior and has a repairing obligation. So they're going to be the principal accountable person. So if someone else has responsibility, say for the grounds or the swimming pool or whatever it is, okay, they might be an accountable person on the definitions we looked at previously, but the principal accountable person is going to be the one who owns structure and exterior and has a repairing obligation in those. And that, I think we can see makes sense because those are the highest risk areas for the building. That's where the fire or the structural failure is going to be. So that's going to be the principal accountable person in those situations. If you're squabbling about it and you want to be the principal accountable person, or more likely you or your organization don't want to be the principal accountable person, you can apply to the first tier tribunal for a decision from them as to who is going to be the principal accountable person. Or you may say, well, we only want to be the principal accountable person for this part of the building, and it should be them for the other part of the building. The tribunal does have the power to take that decision. That's in force at the moment. I'm not aware yet of any applications that have been made to any tribunal around the country, but that will give people the ability to do that. Just going to check the other question that's come in. So the occupation, phase, and duties of the principal accountable person and accountable person interaction between both. Does this cover complex buildings where it isn't clear who is the PAP or AP and where a PAP is compliant? So if it's not clear, that definition should have told you. If the definition isn't enough, then you go off to the tribunal for a decision from the tribunal as to who will be. What if a principal accountable person isn't compliant? Well, we'll look at that in a second because there are fines and sanctions available against them. Thank you. Keep those questions coming. So what's next? How are they going to stop people living in dangerous buildings? So section 76 of the Act, which is in force for new higher risk buildings. This is stuff that's being built since the Act came in, okay? Or where you've got an existing building that's high risk and you're adding, as we like to, a couple of stories on top. Okay. Or if you're doing works that make it a higher risk building, so you had 6 stories and you're sticking 2 on the top of an existing building, then that automatically takes you above the 7 stories. So where any of those apply, so this is brand new developments or developments that have become higher risk, then you can't let people live there. No letting them move in until you've had a certificate under building regulations issued. Okay, there must be a completion certificate issued before you can let people move in. Well, does it matter? You go, will they mind? Well, yes, criminal offence can be fined or sent to prison. So that's the principal accountable person can be fined or sent to prison if they let people move in and you haven't got yet sign off on building regs. Another bit of sanction here coming in. Okay, this one's not yet in. The whole building will have to be registered. And for any higher risk building, that's going to have to be registered. And when these are in place, you won't be allowed to let people live in the block if it hasn't been registered with a building safety regulator. Now, at the moment, they are hoping, the regulator has said that they hope to open up the registration list in April 2023. And they are expecting to, in effect, close it in October 2023. So you will have those 6 months to get your buildings registered. I very much hope that any organisation here, whether private, social, housing association, local authority, university, etc., you already know which of your buildings are going to be higher risk. So it shouldn't be difficult for you when they open this up to get them registered. But at the moment, the regulator is promising that will be opening up in April 2023. So again, as I said, I would sign up to their mailing list because they will then let you know when that's open. But we're looking at April to October to get your buildings registered. If by October 2023, you have a higher risk building, which has not been registered, there should be nobody living in there. Nobody at all. So again, that will be a criminal offence. It's going to be a criminal offence for each person that lives there. So if you've got a large block of flats that somebody has failed to register because they went off sick in about March 2023 and nobody noticed in the next sort of 7 months, the organisation, if it is an organisation, is committing a criminal offence and several criminal offences. So we could be looking at some fairly chunky fines. So can you all please make sure that you know which are your high risk buildings? As I say, you should do already. And can we make bloody sure that we're ready to go as soon as that registration list is open? April 2023 is planned. Otherwise, there's criminal offences coming in. So that section 78 tells the regulator it's got to keep a register of higher risk buildings, places the duty on the regulator. What else can the regulator do? So if there is a higher risk building, the regulator can say to the PAP, the principal accountable person, you must go and get a building assessment certificate done. If the regulator tells you you need to do that and you don't, then again, it is a criminal offence not to. So what are they going to need in this building assessment certificate? Well, this bit's not in yet, so this could change, and I suspect there will be further regulations. Well, there almost certainly will be further regulations coming in, but an application to get a building assessment certificate will need a copy of the most recent safety case report, and we'll look at that in a second for the building. Any prescribed information about how you as an organisation are reporting mandatory risks and fires and that sort of stuff. There's going to be prescribed information that you're going to have to supply to say how each accountable person for the building, and remember, although there will be one principal accountable person, there may be probably only 2, but there may be 2 or 3 accountable persons for the building. So that prescribed information will have to be supplied with your building assessment certificate, and a copy of any residents engagement strategy. The social landlords and local authorities amongst you will probably find that fairly easy to show how you engage with your residents. Private developers, perhaps not so strong on resident engagement, and you may need to work on your strategy. This bit's not in yet. That's why we're white at the top of the screen on the heading there, but it's going to come in. So you need to start thinking about how we're going to look at those. The regulator is going to have to actually look at what you send in and check to see if you're complying with your duties. That's his job. If he's not satisfied that you're carrying out your job, he must refuse your application for a building assessment certificate. Will be interesting to see how many of those get through. It's not supposed to be a tick box, just nod it through exercise. They're supposed to do a check and make sure everything's happy. Oh, I've done something odd here with my screen. What the regulator is allowed to do is to say, okay, you haven't satisfied me, so I'm not going to give you the certificate. The regulator has been told that he can say, okay, you can put that right. But the Act says quite clearly that any breach, he can only do that if any breach is going to be remedied promptly. Now, of course, there isn't a definition of promptly, but I think it's fair to say that the regulator won't be saying, right, I need your certification and you've got a year to put it right. I would imagine that they'll be looking at something like weeks or perhaps a month to put those right, because all of those things should have been in place that you needed to get your assessment certificate, and the regulator's allowed to give you a chance, but only if you can get it right and remedy that breach promptly. Right, let me just check another question. Okay, so there's a question about leasehold obligations. I'll be dealing with that. Bukola and I are going to cover some of that. Yes, it will deal with existing leases. Keep the questions coming. So, what other duties are going to be on you as a accountable person or principal accountable person? Well, you're going to have to display. So we just looked at building assessment certificates that you would be required to get, or the regulator can force you to get. You're going to have to display in a conspicuous place a building assessment certificate. A notice about who the accountable persons are. Any compliance notice that the regulator may have served on you. Okay, so all of those 3 things are going to have to be displayed in a conspicuous place. That presumably is the notice board somewhere near the front door. Those of you who run some of these blocks will realize the difficulty in having such notice boards, and how the fact that people like to tear down your notices or cover them up with their own advert for the jumble sale or the lost cat dog photos, etc. That wouldn't be acceptable. You're going to have to show that they are displayed. I think some companies are now offering you very secure, guaranteed, fireproof displays. People have asked me about electronic displays. That would seem fine, but I don't really see how all of this information is going to be able to be done electronically, because you've got to display the certificate, for example. So I don't quite know how that's going to work. So the other duties, Section 83, you've got to assess the building safety risks. And sorry, let me get rid of that. And you're going to have to carry out and repeat your assessment at regular intervals. You can't do it once and go, that's fine. Back in 2022, we assessed the building and it was all nice and safe. And you can't rely on that for years to come in the future. If anything has changed about the building that your assessment makes it no longer valid, then you will have to do a new assessment. So fairly obviously, if you change the cladding on a higher risk building, then almost certainly you're going to have to do a new assessment. Will a change in your residence perhaps having some more vulnerable residents in there. Will that mean that you need to change your assessment? So you've got to do it regularly, and you've got to do it again fresh if your assessment is no longer valid, or you've got to do one when the regulator tells you you've got to. What other duties are there being passed down to you? Section 84 confirms that in a higher risk building, the accountable person must prevent a building safety risk materializing. Hopefully you would do that anyway. So the collection of wood that one of your residents has put on the balcony because they're going to redecorate their house. The classic pram blocking safety exits. Okay. I think we're probably all fairly good on gas barbecues and gas cylinders and things like that. But anything that is creating a building safety risk, you've got to try and prevent it. You've got to reduce the severity of any risk. You're also going to have to do a safety case report. Now that's, if you go back, we looked earlier about the building assessment certificate that you might have to be asked to do. That included, if you remember, your safety case report. So as soon as practicable, you're going to have to do a report on the risks that were in Section 83. You're going to have to include in the building safety case report the steps you've taken to prevent the risk materializing or reduce the severity of any risk. And then you're going to have to tell the regulator what you've done. So all of those things are going to be imposed on you. Section 87 sets out the rules as to mandatory reporting and how he's going to want that. That's not in yet, so we'll wait and see what the regulator comes in. That will come in through regulations. Section 88, you're going to have to keep prescribed information. Again, we don't know exactly what that prescribed information, but it'll be the sort of things that we've just looked at. You're going to have to keep it up to date. You're going to have to keep copies of prescribed documents. I think electronic versions will be fine. You're going to have to hand over prescribed documents if required to do so. Quite sensibly, if the accountable person changes, then you must report that to the regulator. It's no use to the regulator looking for the principal accountable person or any of the accountable persons if they've retired, the business is shut down, they've sold on the leasehold interest in the property. That's going to have to be reported. Whether you're going to do that yourselves, whether you're going to get your lawyers to do that, I don't know. But somewhere you're going to have a system in place to notify the regulator if the accountable person changes. What other duties have we got? Section 91, you're going to have a residents engagement strategy. You're going to have to promote the participation of residents in building safety decisions. Now, of course, if you look at Grenfell, one of the concerns was that the residents had been complaining about building safety for some considerable period of time and felt that they were being ignored. Whether that's right or wrong, that's for someone else to decide. But they said nobody was interested in our thoughts, our views on the safety of the building. So you'll now have an express duty that will be in on how you will get your residents involved in decisions about the safety of the building. You're going to have to give a copy of that strategy to every resident over 16 years old in that block. Some of your bigger blocks, that's quite a lot of copies that you're going to have to hand out. Do you know who's living in your properties? And do you know who is over 16? Now, I've been asked, and I haven't yet worked out the answer, what happens if somebody becomes 16? As far as I can see, it's going to be anyone who's 16 at the time this bit of the Act comes in, or anytime there's a new letting of the property. I don't think you're going to have to keep a sort of birthday register of the children, and as soon as they become 16, send them a cake and a copy of your residents engagement strategy. But we will wait and see. It looks as though it's going to be at the time the regs come in, and then for any new letting. A copy goes to every resident over 16 years. So it doesn't matter if they're not your tenant, it doesn't matter if they're not your shared owner or your leaseholder. If they're living at the property, they should be getting a copy of that strategy. Other duties in place. You're going to have a complaints procedure to deal with any complaints about building safety. Amusingly, also, the next section says that the regulator has got to have a complaint system about himself or herself. It is, in fact, a man at the moment. So the regulator's got to have his own complaints process. There are duties, you'll be pleased to hear, because all of this is on you lot. So far, there's a little bit on your residents, your shared owners, your leaseholders, your tenants, okay? Section 95 confirms that they must not create a significant risk. So they're not supposed to be bringing in anything that's going to create a significant risk. They're not supposed to be blocking stairwells, fire escapes, etc. There may be arguments as to whether that's significant, but they're not allowed to do it if it is significant. They are not allowed to interfere with a safety item, whether that is a self-closing door, a fire extinguisher, the dry riser main, or whatever it is. Anything that relates to the building safety, they can't interfere with it. You'll be pleased to hear. If they are asked questions about building safety, they must comply with it, that request. And the accountable person, that's pretty much you lot, you can serve a contravention notice on them saying you haven't done either of those things. If they have set off your fire extinguisher in a sort of student prank type way, or perhaps maliciously, you can say to them, right, that was a safety item. I've had to replace it, or I've had to repair it. Pay up. Now, there's an argument that you could probably have done that anyway under terms of the tenancy or the lease, etc. But if there isn't such a clause, whether you want to call it a recharge or however you phrase those things, you can now, as a principal accountable person or an accountable person, you can require them to cough up for the cost of replacement or repair. Whether you get the money out of them is another issue, but the Act says that you can do that. You can take them to the county court to enforce that obligation. Okay. And you'll also be pleased to hear that under Section 97 of the Act, they've got to let you in. If you're carrying out the duties under the Act, Section 97 says that they must let you in. Now, in most of your tenancies, you will have clauses that say something like you must give us access to do inspections, carry out works, etc. You could probably rely on those fine. Similarly, in shared ownership tenancies, you will have that. Leases tend to be less well drafted about giving access. But whether you've got those, or maybe you think there was a clause in the tenancy, but somehow at the time of the stock transfer, the tenancy went missing. So we haven't got a signed copy of the tenancy agreement. Somebody must have misfiled it. Doesn't matter if you haven't got a written clause. Section 97 is if you're doing this for your duties under the Building Safety Act, they must give you access. And again, you can go to the county court to enforce that. So that will presumably be the injunction to gain access under Section 97 of the Building Safety Act. Looking forward to doing my first one of those. Section 99 says the regulator can serve a compliance notice on an accountable person. Oi, put this right, you ain't carrying out your duties, and failure to comply with the compliance notice is a criminal offence. You'll see all these criminal offences coming, and that's why you want to make sure you know whether you're the accountable person or the principal accountable person. And just to make it a bit more serious, if you haven't complied with the compliance notice and you are placing people at critical risk, then that is a more serious offence. That can go up to the Crown Court. So there's longer prison sentences, bigger fines that will come in under Section 101. There's also a bit that will come in Schedule 7 of the Act that will allow the regulator to serve a notice and then seek a special measures order through the tribunal and appoint a special measures manager who can take over the management, start collecting in monies, etc., to do works. So the regulator, in effect, has got the ability, if you haven't complied with the compliance notice, to take over the running of the building, which would be A, embarrassing, and B, a considerable pain. So the regulator is going to have quite big powers. Now, I think this is my opportunity to hand over to Bukola.
It is. Thanks, Daniel. Thanks so much. I'm conscious actually that we have an hour for this section and then later on this afternoon. So what I might deal with is Schedule 8, which is what we're going to talk about now, and then possibly carry the other section of Part 5 over. You just let me know how you feel, Daniel, as we run through. Okay.
Yeah.
So Daniel's going to be my assistant here, and he's going to use his mouse to get all my my notes on. So Daniel, if you could pop in the entire slide, I think it's probably easier. That way I can talk around the slide. We've had a couple of questions in relation to leasehold terms and remediation costs and stuff. So hopefully that's helpful. So I'm going to talk about the leasehold terms and Schedule 8, which is remediation costs under qualifying leases. So Schedule 8 is all about basically leaseholders' liability to pay service charge, and that came into force on the 28th of June of this year. So paragraph 1, I think we need to just talking about it generally. Paragraph 1 of the schedule sets out the definitions of the words, the phrases that are used within the Act. So it's really important part of the schedule. Many of the terms are already sort of captured in part 5, which I'm going to talk about a little bit later. But I think it's important to also highlight a few of those key phrases at that time, because as Daniel said earlier on, it's pretty long and they can be quite complex. But helpfully, each defined term includes the relevant section of the Act as you're going through Schedule 8. So just in terms of a couple of the definitions I thought I should highlight here for the purposes of the recording is the meaning of prescribed within the Act, which is the regulations made by the Secretary of State. Also the relevant measure, which is the requirement that needs to be taken to achieve 1, which is the remedy of the defect itself. 2 is preventing a relevant risk, and 3 is reducing the severity of any incident resulting from a relevant risk materializing in the first place. So the question is, what is a relevant risk? Again, it's within the Act, but I wouldn't say it's as clear as it could be. And it's essentially where the building safety risk that arises as a result of the defect itself. Now, I know that sounds a bit fluffy, but as we start to sort of work through the definitions and part 5, it will hopefully become a little bit clearer. So the other definitions to highlight, and I know a question has been popped up about this, is service charge. And this is one of the last definitions within Schedule 8, but it states that the service charge means the same as it does in the 85 Act. That's the Landlord and Tenant Act 1985 and Section 18 even. I don't necessarily think it does actually fit squarely into Section 18, but I'm sure there's other lawyers on the line, and Daniel may disagree, but I think it actually has a wider meaning. And I think because it includes premises that do not include the dwelling itself. And Daniel talks about commercial premises and other premises like that. So I think it's actually a bit wider than Section 18. So I would encourage you to revisit Section 18 of the Landlord and Tenant Act. So that's paragraph 1. Paragraph 2 of Schedule 8 is where there's no service charge payable for defect for which the landlord or an associate is responsible. Paragraph 3 talks about no service charge is payable at all if the landlord meets the contribution condition. Paragraph 4 talks about no service charge is payable where the lease is below a certain value. So in Greater London, I think that's 325,000. I'm pretty sure it is actually. And outside London, it's 175,000. We've got that on one of the slides coming up just for ease of reference. Paragraph 5 talks about the limit on the service charge that certain leaseholders are required to pay for remedial works. And paragraph 6 is the permitted maximum, of which they are only 4. And they range from 10,000 to 100,000, depending on the value of the lease. It's also known as a cap. I think somebody asked a question about whether there is a cap. So there is a cap in that sense. The total amount a leaseholder may be charged by way of relevant service charge is defined in paragraph 5 of the schedules, paragraph that I just mentioned. Paragraph 7 is the annual limit. So there's an annual limit as well in the service charge. And paragraph 4 and 5, they limit the total amount of service charges payable for the relevant measures over a period of 5 years. So this paragraph limits the annual amount payable for those measures in place. Paragraph 8, again, there's only 9 paragraphs I'm going through because I think they're the most important, but paragraph 8 is where there's no service charge payable for cladding remediation. And I think again there was a question just popped up about that. So essentially it's to relieve every leaseholder of, well, in a qualifying building, from any obligation to contribute towards the cost of cladding remediation, full stop. Paragraph 9 talks about no service charge payable for legal or professional services, and that's relating to the liability for the defects itself. And this really aims to prevent the costs being passed down to leaseholders by way of service charge for solicitors' costs, etc., etc. So that's the 9 paragraphs that I think are very much important in Schedule 8. If we pop over to the next slide, because we still have some time. Thanks, Daniel. If you just pop them all through. So at least they're there on the slide, but we'll talk around them, or I'll sort of talk around them. So the leasehold additions to the Landlord and Tenants Act 1985, so it has been expanded. So section 30D of the L&T Act 85 applies to a relevant lease of a premises which consists of or includes a dwelling in a high-risk building, which Daniel discussed a little bit earlier. So a relevant lease for the purposes of this provision, this act, is for a term of 7 years or more. And the building safety measures are set out in paragraph 4, which is A to N of the Act. And that's referring to Building Safety Act specifically. Just going, we've listed down here the sections that can't recover costs, and that's A to D, and that's just set out for you in a simple way. But it's costs incurred as a result of any penalty imposed or enforcement action taken by the regulator. Again, Daniel touched on that earlier on. I talked about the legal costs incurred in connection to special measures of order proceedings, and the costs incurred by reason of any negligence, breach of contract, or unlawful act. And that's all within the 85 Act and those additional new sections. The cost prescribed also, which is D, by future regulations. And those future regulations, as we said before, we're all still sort of waiting to see what they are. Daniel, if you go to the next slide, please. Now, we included these sections in, and as you can see, Daniel mentioned that anything that's in white is what we're still waiting for. The 87 Act, this is more of an aid really to consider what will be coming in later on. So the next 2 slides are really for information purposes more so. Section 113 of the Act says that building safety information to be included in the rent demands. That's all that. So that will include the demand notifications that we put through on service charge as it stands. That's the rights and obligations of leaseholders, the tenants, not just the leaseholders, so that will be included in the demands. That's an additional requirement for what we would usually do in a standard service charge amount. And if it's not included, rent and service charges, etc., it's not payable, as we have now with all types of service charges, without including that that additional information.
Thanks, Bukola. So yeah, so I think the important thing to note here is that you're obviously used to putting your name and address on rent demands and service charge demands. If you've got a higher risk building, you're going to have to put all of this additional building safety information out on your demands. So you're either going to have a system for splitting out 2 different types. So we've got one rent demand for most of our residents and another type of rent demand for the higher risk buildings, or we're going to have to put the building safety information on all of our rent demands. It's up to you a lot to work out what you're going to have to do when this comes in. As Bukola says, that's not in yet, but you're going to have to worry about that. And I'd start worrying about it this afternoon if you haven't, because you're going to have to talk to IT and finance as to how you're going to do that.
Yeah. And I think, again, that the thing to stress is that if it's not in, then it's just not recoverable. And that's the main thing. Next slide, I think, is, again, just setting it out. Daniel just talked about some of the information that will need to be in, but the information can be given to prospective tenants, and that's under section 49A, that the premises consist of or include a dwelling in a higher risk building, the name of the accountable person and the regulator, an email address and telephone number for that person, a postal address in England or Wales for the principal accountable person, again, a postal address for the regulator, and such other information as may be prescribed in the regulations by the Secretary of State. Again, the reason why that's put in is because such other information can and will continue to be included as we sort of see this act really come into force, come into play. So next slide, please, Daniel, unless you have anything to add there.
Oh, no, I was just going to say, again, you're going to have to work out your whatever you call them, your lettings team, your allocations team. You're going to have to work out, are we giving all of this information, or are they going to know which are the higher risk buildings for which we're going to have to supply all of this to any prospective tenants? Are we going to have to supply this to all people who have a viewing, all people who get offers, or only when we sign up to a tenant? It talks about a prospective tenant. So I guess we're going to have to do this at the early stage. If, say, we're a housing association and we get nominations from the local authority, and we should have an ability to somewhere on the system go, yeah, this is a higher risk building. So that information is going to have to be given out to anyone who's nominated to us because they're a prospective tenant. So yeah, quite a lot for you to think about.
Yeah, I think if we go on to the next slide, yeah, part 5. So part 5 has quite a bit to it. So I think we should probably stop there at 12. I think this is scheduled from 11 to 12. Is that right? Or is it 11 to 1?
Perfect.
Yeah, I think we should stop at part 5. So when we come back, I can go through the amendments that actually took place in February of this year to part 5, and then we can continue there. If that's all right with everybody.
They can't. They have no
they
choice.
can't.
They have
can't
no
talk.
choice, Bukola.
Yeah,
You
of course.
and I are the only
I'm
ones who can
hoping
talk.
everyone's just nodding. Yeah,
I don't believe in democracy. You and I will decide what we do. No, we will stop there, troops. Thank you so much.
I
will have a look at the questions and answers. I think quite a few of them are going to be covered in this afternoon session. If they're not going to be covered in the afternoon session, I will deal with them at the start of the afternoon. So thank you for all your questions.
Also, if there's any questions within this hour, or between now and when we're back, you could populate them or just write them down so that when we're back online, you can hopefully answer them there, because there's quite a lot of information there.
Okay. Otherwise, thank you, Bukola. Thank you, everyone. Otherwise, we'll see you all back at 2 o'clock. Go and get your lunch, or in my case, go and pick up your mum from the shops. And we'll see you all back at 2 o'clock. Cheers.
See you. Bye.